It's very important to retain an attorney early on in your slip and fall because we can help you avoid these pitfalls. Hi, my name is Mark Servais. I'm an attorney at Michigan Slip and Fall Lawyers. I've been here for over a year. Our client had this slip and fall at this national grocery store. One of their employees had mopped the floor and did not put out a wet floor sign. And it was right in the self-checkout area of this store. Now, our client was able to get up off the ground, and his first reaction, as he stated in his deposition, was that he was embarrassed. He just wanted to get out of there. Didn't even see the condition on the ground that caused his slip and fall. He then left the store, went about his day. Next day, he wakes up, he's in some pain, some back pain, some shoulder pain, tries to tough it out a couple days, and then the pain just keeps getting worse and worse. And his doctor is the one that does some imaging and says, hey, you have a fracture to your spine and also a torn rotator cuff. Both of them are going to require surgery. These slip and falls might seem like something minor, but it's very important to follow up with your doctor. They're the healthcare professionals. The issue with the case was when he reported it to the store, he couldn't remember which day the slip and fall occurred on. He was a retiree. It wasn't something that he readily remembered the exact day. He didn't seek treatment that day. By providing the wrong date, our client didn't allow them to save the correct video. They saved the video for the date that our client had originally told them. Just to nail down the date that our client was in the store, we had to do a little legal wrangling on our end, in the sense of we went and got his customer data from the defendant in order to prove that he was in the store making a purchase that specific day that he slipped and fell, which was unfortunately one day off from what he provided on the incident report. A lot of times with these slip and fall cases, the corporations won't disclose any of this information. A lot of times it takes filing a lawsuit or sending a preservation of evidence letter to the corporation in order for them to retain the video. Again, their retention policies are set in place to eliminate the video within 30 to 45 days. It's very important for anyone that's involved in a slip and fall at a store to go to a manager or customer service and let them know that, hey, I was involved in a slip and fall at this store. Let them know the date and time. And the earlier they can do that, the better, because when you file those reports, it triggers the store to maintain all of the critical evidence that we've been talking about, the video, any data that they have from you being inside the store. And those are all very big components in proving the liability, proving the notice that they had of the dangerous condition within the store. So it can't just be someone spilling a pop on the ground and you walk up and slip on it, a minute later. The store had to have known that there was some kind of condition on the floor or that existed where they needed to take action for the safety of their patrons or the public. It took several depositions for them to admit, or for anyone to admit to have seen our client fall in the store. When I deposed the store manager, he says, your client said he slipped and fell on this day. That's the video I retained. And that was the level of investigation. The stores don't want to find the video because it's going to prove that our client had the slip and fall. And if our client gives wrong information, bad information, then we lose that video. And again, it made the case much more difficult than it had to be. But we ended up eventually finding an employee that testified that he did witness our client fall, and that was kind of the domino that led to the settlement. If no one else inside the store witnessed the slip and fall and we don't have video, all we're going on is our client's word, which makes the case a lot weaker. We reached a fair and equitable settlement with the store for $325,000 for the injuries and the pain and suffering that our client suffered. And we thought that was a reasonable value given the circumstances, given the negligence of the store, not being able to, pick up his grandkids, do things with his grandkids that he normally would have been doing just fine. He used to go to their baseball games and help out. And after that, it was much more difficult for him to just even live his daily life